The Secret Service, British agents tasked with delivering foreign intelligence, information in secret. But what happens when that information contains details of human torture? Should it remain confidential? British victims of torture don't think so. 16 people have been through the civil courts to discover Secret Services knew about their inhumane treatment abroad. Compensation claims amounting £20 million have been paid for by the British taxpayers so far. The coalition now wants to stop information of this nature being revealed in court. Which raises the question, what else do they not want the public to know? And who are they trying to silence? Britain is globally revered for its open justice system. Every member of the public has the right to attend a civil court hearing and to listen to evidence presented. However, this is set to change. Kenneth Clarke, Secretary of State for Justice, has delivered a green paper proposing civil court proceedings involving sensitive material be held in private. Joel Benantham, QC from Tooks Chambers, outlines the legal issues a change in law will present.
The law at the moment is very straightforward. If one person sues someone else, they go to the High Court in this case and say, you've done me wrong, you should pay me damages, then the claimant and the defendant both put evidence in written form or through witnesses they call. Everyone can hear it, and the judge, or sometimes a jury, but normally a judge, will make up his or her mind. They'll find for one side or the other, and they'll award some damages if the claimant wins. Now, the government's green paper suggests there would be a new scheme whereby evidence that one side rely on, and it would always be the government for these purposes, would remain secret. So the judge would see it. There would be a mechanism whereby special lawyers on behalf of the claimant, but lawyers who couldn't talk to the claimant, would look at it. But basically the judge would be looking at the evidence of one side, and neither the public nor the claimant would be able to see that evidence to understand what's going on.
Labour Minister Jenny Chapman from the Shadow Justice Department tells us why she believes the government is making the right decision.
I think unusually there is, broadly speaking, cross-party support for this particular green paper. I think there's a recognition that these issues are not straightforward, they're very complex, and we need to reflect the fact that we live in a society where these issues do need to be addressed, and that all parties see the protection of the public as being central to consideration, but also understand the need for people's civil liberties to be protected too.
Although supported by MPs from all major parties, the Green Paper will have a detrimental effect on those British citizens seeking crucial answers. Tara Lyle, policy advisor from Amnesty International, is deeply concerned about the proposed legislation.
We look at the reason why these proposals came about. They followed a number of civil cases where former British nationals and residents who were detained in Guantanamo Bay brought a civil case against the government, suing them for involvement in their torture, rendition, other mistreatment. Held in secret means that the people concerned, the people who have been victims of these human rights abuses, won't have an opportunity to cross-examine that evidence, they won't have an opportunity to challenge it, they won't even be able to really find out the truth about what happened to them. UK government involvement in torture is something that I think is of interest to everybody. These are the sort of secrets that we don't think are worthy of protection.
Mozzam Begg, born in Britain, spent 5 years in Guantanamo Bay, where he was tortured and abused.
I did experience what I would regard as torture in the Bagram detention facility and in Kandahar, where I was held in Afghanistan by the United States for about a year or so before I was shipped off to Guantanamo. I was subjected to all sorts of abuses, cruel, inhuman and degrading treatment, which included being stripped naked and being beaten and punched and threatened with being sent to places where torture at that time was notorious, i.e. Egypt and Syria. What I can say about the compensation is that the government still regards that it was an out-of-court settlement as opposed to a compensation. And the reason why this happened is that we maintain, myself and several other former Guantanamo prisoners, that we would not have, and particularly in my case, I would not have been sent to Guantanamo had it not been for the British government and the intelligence services in particular, who were involved in me being, or complicit in me being sent over, me being held. They were there at every leg of the journey, when I was in Kandahar, when I was in Bagram and Guantanamo. Intelligence officers were very much part of the reason why I was in Guantanamo.
There is strong support from inside Parliament, and it has been suggested the new law will be passed in autumn 2012. Outside Westminster, sceptics and human rights campaigners fail to see how this law will benefit those currently imprisoned, tortured, or betrayed by the British government. It would seem the secret intelligence services are stuck between protecting its citizens and protecting national security. The CIA refused to cooperate with MI6 when it revealed American intelligence as evidence in an open court case last year. Cooperation with foreign intelligence services is important for Britain's national security, but at what cost? It is now up to the UK government to decide what is more important, its people or its relationships with other countries.